the cloud. Okay. And so what we're going to be talking about this third of the semester is now we're going to start talking about contracts. So the way the semester is broken down, it's broken down into 3 different segments. And so the first segment, which we've just completed, is a segment with all different types of law. So it's a little bit of everything just to kind of get your feet wet with introduction to law. The second third, which is what we're about to embark on, is the nitty-gritty of contracts and how you should look at contracts and what makes a contract. And then the last third of the semester is going to be spent on business formations and a little bit of sales, business entities and taxation and things of that sort. So this is focused on contract. And when I talk about focus, the nitty gritty, we're going to get into specifics of it. So today's lecture on chapter 9, it's kind of like an overview of what we look forward. And then you'll see that according to the syllabus, the subsequent chapters, we kind of delve into a little bit more detail into the things I'm going to be talking about today. So if there's something that you don't get, that's okay. We're going to be talking about it into more detail over the next 2-3 weeks, and then you'll get it. Generally speaking, just so you're aware, the first exam, right, is easier than the second. Generally speaking, over the past X amount of years that I've taught, the second exam is actually the hardest. You would think that it's less material, it would not be as difficult, but because I'm asking now more specific questions and asking you to analyze and think, it may be harder. So again, it's important for you to understand the differences with different things and understand what I'm actually asking. And then the other thing is, again, the exams are now different. It's multiple choice and true and false only, so there's no short answers. So maybe that's already an automatic booster. But I kind of just want to give you the warning, that way you know. And again, as I would do in the past, if I tell you to write something down, it means it's important, you should write it down. If it's like, oh, listening, this is for your own knowledge so I can make you a smarter, more intelligent person, then just listen, it's kind of for your own good. So anybody have any questions before I go ahead and start with chapter 9?
Yes, Professor, I just had a quick question.
Sure.
You're recording this session, right? So we'll be able to go back?
Yep, I'm gonna post it on YouTube like I like the things that you would see in the past. So I'm gonna post it on, and then I'll send you guys the link to it.
Okay, great, thank you.
You're welcome. Okay, so let's see here. Okay. Okay, the wonderful world of contracts. Believe it or not, you actually have entered into contracts many, 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 many times already without even realizing it. Every time, somebody's asked a question. No, the exams are not cumulative. So I will not be asking anything about wills, criminal law, or anything like that. Second exam is just going to be focused on stuff from today to the second exam. Okay? All right, so back to contracts. Anytime you purchased a phone or a computer or obviously a home or a car or anything, you had to sign a contract. Did you actually, let's start with something simple. If you've purchased a phone before or you've downloaded software, was there a contract? Do you remember a contract being presented to you? Yeah, that term thing. Yes, that's exactly those terms that you have to sign off on before you're actually allowed to use the phone or the software. That's a contract that's being presented to you, and you're agreeing to those terms of the contract. Otherwise, you're not able to use the phone or the device or anything like that. So there are contracts all over the place, and there's different types of contracts, and the court, I'm giving you just a general overview, the court looks at contracts in different ways. And there was a point in time and a point in history where contract disputes were kind of like the wild, wild west. There was really nothing to codify them, right? There was no law that says, if this, then that, like criminal law. Like, there's definitions of criminal law. If you committed murder or if there's robbery or burglary, if you recall, there were elements, and if those elements are met, then you would have had a crime. Contracts were different. It was, what happened in this jurisdiction may not necessarily apply to a different jurisdiction. There was no really set rules or guidelines. And so what happened was there is this thing called the restatement. This is, again, just listening. And it was made by the American Law Institute. And it's not actually law itself, but it's this kind of a codification of contracts where they kind of started to put together documents or ways to assess what a contract is. And this actually just started in 2012. And the UCC, the Uniform Commercial Code, Article 2 in that UCC governs the sale of goods. Every time you buy and sell something, there's a contract there. So the UCC governs that. And so there became then this way to analyze contracts, whether it had to do with the purchase of goods or whether it had to do with the service. And sometimes you would apply a different standard depending on what the underlying cause was. The question also then came up as, well, when do you apply the sale of goods and when do you apply the service aspect? What if I'm hiring somebody to install tiles in my bathroom and there's something wrong with the tiles? Well, is it the tiles itself that there was a discrepancy with, or is it the workmanship that was not good and caused the tiles to be broken or somehow not fit together, right? So again, contract is still the same thing as I've told you before, where it is based on the fact pattern. You have to ask questions, you have to look into the detail, and you have to kind of look at the big picture and then narrow it down. And every case could be different, but there'll be common threads. When the court looks at contracts and kind of begins that analysis, one of the first questions we ask is the dispute over goods? And what are goods? Can somebody tell me what goods are? When I talk about goods, what's good? What's a good? It's not how you're feeling, so.
Is the thing that we can touch, like
Yeah.
table.
Yep, exactly. It's exactly that. Goods are tangible property, okay? It's personal property, things that you can touch. So it's like a table. It is like a computer. It is like a car. It is not real estate. It is not land, okay? So when we talk about the sale of goods, we're talking about tangible stuff, okay? We're talking about things that we can touch and do things with. That's the sale of goods. And so that's the first thing that we're going to be asking. And so when we talk about the sale of goods, then a particular law is going to be applied. It's that UCC Article 2 kind of thing. And that's what codifies things. Now, the next step in analysis, once we know that we're dealing with a good, is we look at the type of agreement that was made. I'm going to say something to you now that blows your mind. You're going to now sit there and think about this, and you're going to see, well, does this make sense? Does this apply? All contracts that are entered into are actually promises. So all contracts are promises, but not all promises are contracts, okay? So all contracts, every contract is a promise, but not every promise is a contract. So kind of keep that in the back of your mind as we delve more and more into this. When we talk about promises, there has to be essential requirements that make a contract actually binding and gives it a legal remedy. Again, there are some types of contractual obligations that may not be enforceable by law. We're going to get into that in a few minutes. But you want to always think about the agreement that's being made. Is this a contract? One of the other things I'm going to throw out at you, you ever heard the term of oral contract? We had an oral agreement, oral contract. I would tell you to nod your heads, but I only see a bunch of names here, so I don't see anything. Okay, thank you. Yes. So is an oral contract binding? Give me a show of hands with your little icon of hand. Is an oral contract binding? How many people say yes? Raise your hands. 2, 3. Okay, somebody says 4. No.
It
Okay,
depends.
it depends. I feel like it
When we
depends.
have evidence or something, recording, maybe
Well,
video.
so you don't actually need evidence. So it is a trick question. Is an oral contract binding? It depends. It could be. Even if you don't have an actual recording, that certainly boosts up your case. But there are types of oral contracts that are considered binding. And there are things where an oral contract is not good enough. Even if all the elements of a contract are there, if it's oral, it's not good enough. So there are some things that must be in writing in order for the contract to be valid. It's not good based on just the handshake that makes it valid. No, there's got to be other elements to it. So the answer to the question, is an oral contract valid? It depends, okay? Always be careful whenever I ask you those questions of yes or no. Usually, you know, the answer is it depends. It depends on the fact pattern. It depends on the situation. It depends on, what else is going on. So with that said, I'm going to tell you that with every actual contract, there's 4 requirements. I'm actually going to put this in the chat. Okay, this is something that you need to know very, very well. Let me just find it here. Okay, this is what we're going to spend a lot of time on, different variations of. Okay, so today we're going to talk about those elements, those 4 things in general, and then you'll see that the chapters, there's a chapter dedicated to mutual assent, there's a chapter dedicated to consideration, and so forth and so forth. Those entities that I just mentioned, those are the requirements of a contract. Those are the basic requirements of a contract. In order to have a contract, you have to have mutual assent, consideration, it has to be legal, and there has to be mental capacity. If those things are not there, then you don't have a contract, okay? So, and like I said before, there are some contracts that have to be in writing. We're going to talk about that, a little bit later. So don't worry about it right now. So I'm going to just generally now go over the 4 things that I just put in your chat. What is mutual assent? Mutual assent is basically 2 people, 2 entities, 2 groups, 2 companies, whatever it is, agreeing to the same thing, right? So think just simple terms from when you were a child even. Let's say you were at the lunch table and mom or dad sent you a peanut butter and jelly sandwich for lunch, but your student classmate had a cheese sandwich. If you wanted the cheese sandwich and your classmate wanted the peanut butter and jelly sandwich, what would you do? Anyone? Okay.
I would trade.
You would trade. That's actually a type of contract. You want something. You're going to give up this peanut butter and jelly sandwich and you're going to get the cheese, and vice versa. You both have an understanding, if this classmate is willing to trade with you, you both have an understanding that I want what you have and you want what I have. We're going to trade. Contracts are kind of like that, right? When you're buying something from someone or selling something to somebody else, what are you doing? They have something that you want, or vice versa. And so if somebody has something that you want, normally, what do you offer them to get it? I'm going to just say it because nobody's
Money.
Money, that's right. So you give them money, they give you this thing. And so there's a contract based on that. Both of you understand and agree to, if you give me this, I will give you that. Both of you are understanding that same thing. So that's really mutual assent. Consideration. Consideration is probably the hardest out of the 4 to understand, but in simple terms is you give up something to get something, okay? It's not a gift, right? It's very different. Contracts are different than a gift because when you give a gift, you're not expecting anything in return. Consideration in a contract setting, I'm giving something up to get something. Therefore, I'm like giving you my money so I can get something. I'm going to lose my money There's a legal detriment and a legal benefit. I lose something to get something, and vice versa. You lose something and get something. So you're losing your item, but you're getting that money, and vice versa. So that's consideration. The next two are really my favorite. I think they're the best. Legality of the object, right? You enter into a contract, it has to be over something legal. You cannot hire somebody, a hitman or a hitwoman, right? So they can take out your competition, and if they don't do it, you're not going to take them to court to sue them for breaching the contract, right? Because you should not be hiring people to kill other people. You can't do that. That's illegal. So the nature of contracts must always be legal. Whatever it is that you are contracting over must be legal in order for you to have a remedy in court. You can, I guess, contract over things, but you're not going to be able to go to the court and say, hey, I had a problem with this person. They didn't do what they were supposed to do. Therefore, I want to sue them. If it's not over a legal matter, you're not going to be able to do that. The last thing is capacity. Capacity should ring a bell. We talked about capacity when we talked about wills, right? So mental capacity needs to be there. Whenever you're entering into a contract, a valid contract, in order for it to be valid, it has to be with somebody that, again, understands the terms of the contract. You can't enter into a contract with somebody who's already been adjudicated as mentally incompetent and expect them to fulfill their end of the bargain. Even if it was in your benefit and you're basically tricking somebody, the court's going to invalidate that. That's not a contract. Why? Because the person did not have the mental capacity to consent. Big picture is, a contract is something that both sides want to do. There's usually a benefit that you want to enter into a contract with somebody because you want to get something out of it. You're buying a car. What are you getting out of that? You're buying a car and you're giving up your money. If you didn't want to enter into a contract, or you're going to try to find ways to get out of it, then why enter it into a first place? It's a relationship that you want to be a part of, right? So you're not going to actively try to screw it up. That's essentially a contract, okay? So those are the 4 requirements to have a basic contract. Like I said before, there are some times, hold on, I have to yell at my kids because they're getting a little loud. 1 second. Okay, there are contracts that must be in writing in order for them to be valid. If you're contracting over something that's over $500, that must be in writing in order for it to be valid. Okay, if you are contracting over something, this is not concerning land. Whenever you're, I'm gonna yell again. Hold on. Joys of having children. It's wonderful. It's great every day. It's wonderful. Okay, so when we talk about things that also have to be in writing, contract, have you ever watched the show Judge Judy or any of those judgy shows that they have either at night or in the morning? Sometimes people don't have, they say that they've entered into an agreement with somebody else over X, Y, and Z, but they don't always have writing. They might not even have like the text messages or anything like that. And sometimes it's valid. Why? You have to show your case and you have to prove it to the judge by the preponderance of the evidence. That should also ring a bell. That more likely than not, the circumstances dictating your situation show that you are in fact correct, that you are in fact telling the truth. So what you want to do is, forget even what is statutorily or what you need to put in writing or whatnot. I am a big proponent of always putting something in writing, always having some kind of real legitimate proof. Why? Not even to contemplate the thought of a future lawsuit, although that's always on my mind, but it's also just for me personally, you know, I may not remember the exact things that we talked about. If I don't write things down, I'm not going to remember. If you enter into a deal with somebody over something, are you going to remember the nitty-gritty specifics of it? You may not. That's why it's always a good idea to put something in writing. So even though it may be valid on its face that it was an oral contract, always a good idea to put it in writing just to kind of have something to refer to. Why? Memories fade. Sometimes your understanding may be different. For example, if I tell you I'm going to sell my business law book, you see a posting from somebody, a classmate, CSI person that says they're selling their business law book for $50. And you're like, okay, hey, that's a great deal. I'd like to buy it from you. And then you Venmo the money, you get the book. It's like, oh, wait, this book is the, 9th edition. Meanwhile, I wanted the 13th edition. You both wanted, he or she wanted to sell the business law book. You wanted to buy it. But maybe the understanding wasn't exactly there because of the different edition aspect, right? That's why you always want to ask questions and you want to be as specific as possible because it reduces the risk of a misunderstanding or miscommunication, okay? Okay, next, the case now that we're going to talk about, which is on your syllabus, is Steinberg versus Chicago Medical School. Who wants to tell me about that case? It's on your syllabus. It's on for today's assignment. So who wants to tell me about Steinberg versus Chicago Medical School?
Yeah, I can try.
Go ahead.
So the man, the Robert Steinberg, he was applied to the Chicago Medical School, and he paid $15 the fee, admission fee, and the school rejected his application, and then
did they reject his application or did they accept it but reject him?
Oh, I'm not sure.
That's okay.
I thought that maybe they reject. Oh, maybe, yeah, you're right. They rejected him.
Right.
And he made a argue against that, and because he said that it was they rejected that even not they didn't evaluate his application because of the criteria they have in a bulletin or something with the admission, and he said that they evaluate people because they're rich, they have family rich, and they donate money to the school.
Very good. Yeah. So to put it in a nutshell, you did a very good job, Barbara. Very good. This is actually, this case is about the element of the first element that we spoke about, which is mutual assent. See, this guy applied to medical school based on certain criteria that was advertised by the medical school. They said on their application that they were going to be looking at A, B, C, D, and E factors. So he applied, paid his fee based on those factors. It so happens that the school was not basing their admission criteria on A, B, C, D, but they were actually looking at X, Y, and Z, which is family connections, how much money your family's donated, blah, blah, blah. So he sued and he won. Why? Because he applied based on the representation that they made that they were going to be looking at certain factors, and they were looking at different factors. If the school had openly said, we're going to be looking at A, B, C, D, and X, Y, and Z, and then he didn't get in, that's fine. At least he would have known what he was getting himself into. But because they did not fully inform their potential applicants of everything that they were looking at, there was actually, they breached the contract. And where is there a contract? Well, when they said to people, hey, this is what we're looking for, and then he applied, he paid that $15, and they accepted that $15, that's when the agreement was formed. Once they accepted that $15, because now they're going to be looking at him and basing it on the criteria he thought they were going to be looking at, but they weren't. Does this make sense?
Yes.
Thank you. Thank you for acknowledging.
Yes, Professor.
Thank you. Okay, great. So with that said, we're going to move right along. There are ways to classify contracts, okay? And the book gives you a couple of different ways. I care about 3 out of the 4 ways, and I'm going to put them in the chat now so you know those are the ones we're going to just be discussing now. Where's my little chat thingy here? Okay. Okay. The first different way to classify contract is based on express or implied. And that's pretty much, you know, kind of clear in what it means. An express contract is a way where the contract itself is clear. It is the intent of the parties is there. They're either addressing it in words, verbally with one another, or it's in writing, where they're both saying, I want to enter into a contract with you over the sale of my notebook for $10. And that's express. It is clear as day. There's no question that there's a contract that exists. An implied contract is, well, based on the circumstances, based on the situation, based on, you know, what I could surmise, there could be a contract here. Really, the best way I could explain it is, you know, like a wink and a nod kind of thing. Like, you know, do we have a deal here? You know, I don't actually say anything in response to that question, but I give you a wink or I shake your hand. So based on my conduct, you're going to assume that there is a contract there, right? Again, I don't like things that are implied. I like things clear as day, nice and set forward. Do we have a contract? Yes, here it is in writing. That way there's no miscommunication, right? That is expressed or implied. The next one is bilateral versus unilateral. Okay, now in a bilateral contract, each of the two sides that are entering into a contract, they're both the promisor and the promisee, which means in plain English that each side makes a promise and receives a promise. So I'm going to give you examples for that. Whereas with a unilateral contract, there's only one promise that's being made, and it's going to be contingent based on the act. So if I give you like an example, like I promise to pay you $10 if you promise to mow my lawn. So I'm promising to pay you money if you promise to do the yard work, right? So the action is based on the two people promising for one another. The contract is based on those promises. Whereas if I say it this way, I promise to pay you $10 if you mow my lawn. The difference is I'm only going to pay you the $10 if you mow the lawn. If you don't mow the lawn, then I'm not going to give you the $10. It's contingent upon the act in a unilateral, whereas the first example, it's a promise for a promise. So first example to have it as a bilateral contract is that there is two promises, one promise for each. And then with the unilateral, it's one promise for an action. So another example, I'm going to just say it and then you tell me which one it is. I need a ride after school. I'll pay $10 to whoever gives me a ride. Is that a unilateral or a bilateral?
Unilateral.
Unilateral, right. Unilateral, right?
Yeah.
Because I'm only going to pay if you drive me. If you don't drive me, you get nothing, right?
Yeah.
It's not, if I was to say, I promise to pay you $10 if you promise to give me a ride. So if you say, okay, professor, I'll give you a ride after school. I promise to give you the ride after school. Then I might as well, you know, like I could even give you the money right then and there because I'm relying on your promise, not the action. Okay, so that's the difference between a bilateral and a unilateral contract. Again, just to be clear, that in a unilateral contract, the contract is formed when the action is concluded, okay? Because I'm waiting for that action to see whether or not we actually have a deal. Now, the next one, it's actually like 4 things in one, right? So the valid, void, voidable, and unenforceable contracts. What's a valid contract? Simply put, a valid contract is one that actually has those 4 elements that we've been discussing. Okay, so there's that mutual, the consideration, the mutual assent, it's legal, and there's capacity there. When we talk about a void contract, a void contract is an agreement that has no legal effect. It's void. It's like entering into a contract with an incompetent person. You can't enter into a contract with an incompetent person. Why? Because that fourth element, capacity, is not there. Right? Remember I said both people have to have the meeting of the minds. Both people have to understand what's going on in order for a contract to be valid. So if you got somebody who is adjudicated as incompetent to sign off on this contract, then it's no contract at all. It's void. There's nothing there because the agreement is not valid. I'm just going to respond to this person. Okay, good. Somebody else responded. So that's a void contract. A voidable contract is a contract that could be valid, but could also not be valid, right? Let's say you entered into a contract with a person who was slightly inebriated at a party. So you went to a party after work, there was going to be a lot of clients there, and you entered into agreement with somebody to do X, Y, and Z. Now, they were not fully aware of everything that was going on, but they signed off. You had an implied contract that you believed, right? The next day, the person who was inebriated realizes, oh, wait, I shouldn't have really entered into those terms, right? On its face, it could have been a valid contract. The person was not totally wasted. They were just slightly buzzed and, whatever. That is a voidable contract because at the time they entered into that contract, they might have not been all there. But now that they realize that they should not have entered into a contract for whatever reason, they're not going to try to get out of it. So the person who is the victim or the person who was not all with it, they have an option to actually invalidate that contract, to void it out. But they have to do so within a very reasonable period of time. Okay, you cannot wait until the terms of the contract were to begin and then say, oh, wait, I changed my mind. I wasn't actually all there. So a voidable contract is a contract that could be voided by the person who was maybe not, all there or aware of what's going on. The last one is an unenforceable contract. Okay, and an unenforceable contract is a contract where it's really, the law does not give you a remedy. So it doesn't comply with the statute of frauds. So what's the statute of frauds? You entered into a contract over the sale of real property, for instance. You shook hands on it. Both sides were adult, competent, cooperative. Both sides knew what the purchase price and the price and the sale price. Both knew everything that was going on. Buying and selling a house is completely legal. Both sides had the mental capacity. All four elements were there. So why isn't it an unenforceable contract? Well, because I said there are some contracts that must be in writing in order for them to be valid. Buying and selling real property must be in writing. So if you shook hands on that, and then somebody wants to get out, you can't force them to actually go through with the contract. Why? Because it's unenforceable in the eyes of the law. That agreement you entered into must be in writing in order for it to be valid, in order for the court to be able to act upon it. It's like you had entered into an agreement over something that was more than $500. It must be in writing in order for it to be a valid contract, even though you had the wink and a nod and all that other stuff, and you thought for sure that this was a real contract. Well, the law says some things must be in writing. So if the statute of frauds or there's any other like legal entity that doesn't recognize it, then therefore it's unenforceable, and so it cannot be enforced in a court of law. Okay, so those are those things. I think the textbook talks to you about executed or executory. I don't really care about those. So those are the things that I do want you to know. And along the lines of unenforceable contract or things of like the statute of fraud, it's actually a good segue into a legal theory called promissory estoppel. And promissory estoppel is a wonderful, wonderful theory of law that I think tries to kind of balance things out or be fair, right? Ultimately, the law is trying to be fair and give notice to people. So I'm not going to ask you what promissory estoppel is yet. I'm going to ask somebody to tell me about the case of Skeba versus Cash. Please don't forget, I don't assign homework. Okay, so the only thing you're supposed to be doing for this class is reading and coming to class prepared. If it's like a lecture like this, obviously you get away with a lot more if it's pre-recorded, because I tell you what the what the answers are, or what the cases say. But you should be reading as the semester goes on. That way you're not, all befuddled right before the exam. So who wants to tell me about the case of Skeba versus Cash? It's a fun case, really. A lot of fun. Anyone? Skeba versus Cash. It's on today's syllabus. Going once. Going 2 times. Okay, Annie, do you want to tell us a little bit more besides just the chat? Can you unmute yourself? You are correct. Okay. I will just take that as you don't want to talk. So I will fill you in. Annie just saved your life because I was just going to assign this case test on it and not tell you because you're supposed to be reading. Okay, so there was a guy that was working for this company, and he was about to leave the company and go work for somebody else, a competitor. And the people at his current employment told him, no, 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 don't leave. We want you to stay. We're going to give you this bonus. If we ever sell, we're going to, give you all this money. We just want you to stay. So he thought about it, and he's like, all right, fine. So he rejected the other offer that he had from the other company. He stayed on, and he actually helped the company grow, and the company was not really doing very well. And he kept asking them, hey, when can we put this in writing? And they kind of like shrugged it off. Well, the company ended up selling, and they were going to screw him basically. When he was like, well, where's the money that I was supposed to get? When you sold the company, they're like, we don't know what you're talking about. And so he ended up suing, right? And the court said, this is when the court kind of talks about the theory of promissory estoppel. And the theory of promissory estoppel is, it's a doctrine that enforces non-contractual promise when there's a reliance on that promise, and justice is required to enforce it. I'm going to actually put that in the chat for you. That way you have that also in writing. I think it's a wonderful theory, and you know why? It's the difference between having a good attorney and a bad attorney. If you had entered into a contract, an agreement with somebody, and you didn't get it in writing, but you were able to show, this is kind of goes against everything I just told you. But again, it's trying to enforce justice, right? When somebody relies on an agreement that was not in writing, that justifiable reliance on the promise that they were given can make a non-contractual agreement actually contractual and actually enforceable, because to do otherwise would be to not enforce justice. Isn't that beautiful? I mean, I think that's just great. So that's the theory of promissory estoppel, and that's the case of Skeba versus Cash. Okay. That actually, let me just look at the syllabus real quick. That actually concludes chapter 9. We're going to now go on to chapter 10. And chapter 10 is now just focusing on that whole theory of mutual assent. So again, when we talk about mutual assent, we're talking about enforcing an agreement. It's the core of a contract. It is that entity of the contract. It's the meaning of a contract. It's the heart and soul of a contract that both sides are agreeing to, promising to do X, Y, and Z in order for it to be valid. And a contract can exist, like I said before, by what people imply to one another or express to one another. Again, that's the implied versus the express type of contract. And as long as that something is there, then you can have an agreement, and it could be, if it's relied on, then use the theory of promissory estoppel to actually enforce it. When we also talk about this concept of mutual assent, we talk about offers. And what is an offer? See, an offer is something that's needed to have, you know, mutual assent. It's kind of now like dicing and, you know, like dicing mutual assent. Well, what is that? Well, you look at the elements of an offer. And sometimes when you make an offer to somebody, until the actual acceptance of that happens, then again, you have no contract. Because how do you show mutual assent? How do you show that the parties agree with one another? It's that an offer was made and then it was accepted. Or the offer was made, it was rejected, a counter offer was made. It shows that back and forth, okay? Because it shows the parties really understood what they were getting into. It's that, you know, pre-planning of a contract. It shows the effort that was put into it. So when we talk about now the elements of an offer, it's, I'm going to also put this in the chat also. Let me just copy this. Blah, blah, blah. Okay. Okay, when we talk about the essential elements of an offer, it has to be communicated to the offeree. So if I'm making an offer to somebody, that has to be communicated. And I'm going to give you an example of that. I'm going to just go over the other two things first. There has to be, number two, there has to be an intent. You're showing, again, that intent to enter into a contract. That, I think you understand what that is. And it has to be sufficiently definite and certain. When we talk about contracts and the mutual assent element, there has to be some kind of definition, a beginning and an end. I always say this, it's better to tell somebody that you will love them for, you know, the next month than to say I will love you forever. Why? Because forever, there's no, when is that? You know, what is forever, right? But when you say for the next month, I want to be in a relationship with you for the next 2 months. Therefore, it is clear, you know what you're getting into, you know what you're getting out of it, it's there. So it's definite and it's certain. So and the reason I talk about relationships and marriage we're going to get into, it's because that's actually a contract. That's all it is. So when we talk about things that are sufficiently definite and certain, we want to attach that beginning and end. When we remember when I said before that all contracts are promises, but not all promises are contracts. If I say to somebody, my boss, I promise to sell as many widgets as possible. Oh, that's actually really bad, right? Because anything that has hope and you know, like wishing and all that stuff, that's just jazz, right? It's not actually definitive. No, I promise to sell X amount over, I promise to sell, you know, 5 different cars over the next month, right? That's my quota. Let me go back. Go. So that's sufficiently definite and certain. I'm going to go back to number 1 because I love that one. So communicate it to the offeree. So when we talk about the elements of the offer for mutual assent, it's got to be communicated to the other side. What does that mean? Well, if I have a person that's working for me, right, my assistant, and my assistant is doing a great job, so it's Friday afternoon and I decide to myself, I'm going to write a letter to my assistant to say, you are doing such a great job. You come in here, you know, before the work hours, you leave after I leave, you're totally on top of your work. I'm going to give you a bonus, a $25,000 bonus, and I'm going to increase your salary by 10%. And I write the letter. I don't sign it, but I just leave it on my desk so I can go back to it on Monday and finish it up, right? So I leave my office. I say to my assistant, goodbye, have a great night, have a great weekend. I leave. My assistant comes into my room because she's always like leaving me files for the next day. And she sees this letter. Now she's super, super excited. $25,000 raise and a 10% salary increase. That's wonderful. So she goes out that weekend, and what does she buy? She buys herself a nice new fancy car. That's $25,000 worth, right? Now Monday, she comes in all chipper and happy because she just bought herself a new car. She's getting a raise. Life is good. It's wonderful. Now I come into work and I'm miserable. Why? Because over the weekend, we lost our biggest client. So I see that letter and I see her. She comes in. Oh, do you have anything to tell me? Nope, I don't. I have a lot of work to do. Can you please leave right now? I take my letter and I destroy it. Does Alex does my assistant, does my fake person here have any kind of lawsuit or anything? Can she get that 25,000 out of me?
No.
No,
Correct.
because
No.
never said it.
I never communicated it to her. So I wrote it, but I never actually delivered it. It was all in my brain. It might as well have been all in my brain. Even though it was in writing and on my desk, I never sent it to her. It wasn't an email I sent. I didn't hand it to her. I didn't leave it on her desk. It was not communicated. And don't forget, in order for there to have the element of mutual assent be present, both sides have to be on that same level of understanding. So we were not there, therefore that element of offer was not there, and therefore mutual assent is not there, okay? Good, 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 good. Okay, let's move along here. Oh, time is it? 7:20. Okay, I'm gonna give you the secret message for today. The secret message for today, for today's attendance. Don't forget, you're making a list of these secret messages, and once you have 10, you're going to email them to me, and that's how you'll have, 100 as 10% of your grade. If by the end of the semester you only have 9, you'll get 90, and so forth and so forth. So the secret message for today, October 5th, is, I wonder if the schools will close down again. I wonder if the schools will close down again. The secret message for today is, I wonder if the schools will close down again. One more time, final time, the secret message for today, I wonder if the schools will close down again. Okay, I'm gonna move right along. Okay. Okay. When we also talk about offer, you also have to think about whether or not the offer being made was reasonable, or is it actually just a joke? If I tell you, hey, I'm putting up my, what's an expensive car? Ferrari or Tesla or Lamborghini. If I'm selling my Lamborghini for, $50, who wants it? And you jump up and say, yeah, is that a reasonable offer?
No.
No, because I'm not going to sell a car for $50, right? That's not something that's reasonable. So it's probably a joke. Like me saying I'm going to sell you the Brooklyn Bridge. That's a joke. Why? Because I don't own the Brooklyn Bridge. So therefore I cannot sell it. So offers that are being made should also be reasonable in nature. Preliminary negotiations don't count as the actual end of the contract, obviously, right? So you're doing preliminary negotiations so you can get to a final intent. Advertising is not actually an offer. So advertising, when you see sales that are being populated in all these circulars, those sales from a store are not considered offers to you as a consumer. They're just considered advertising. So you cannot say that, hey, the store offered me to buy this TV for $100, meanwhile it's worth $800, therefore I should be able to buy it for that price. When does that happen? Every year. When does that happen? When you see things really very much on sale.
Black Friday.
Black Friday, right? And so what happens is all these stores advertise, these incredible sales. You can go and wait all night long, and then you go there and there's none left. Why? The actual offers say, I want you to look at the circulars next time, for this year. They say limited supply, right? First come, first serve. They may only have one TV or two TVs. You're going to spend all night and you might not even get it. So an advertising is simply that, an advertising and not an actual offer where there's going to be the preliminary negotiations where it could lead to mutual assent. It's just simply an advertising.
Professor, I have a question when
Sure.
we're talking about the sales stuff. Recently, I've been reading some article about there was this thing, there was some kind of promotion, and basically the person came to the store, wanted to buy something, and when she saw the promotion, she decided to buy the product. But when she went to the, let's say, to the cashier store, she's been told that the promotion expired and they just forgot to move these things, and I don't know. So who is right in this situation? Like, do they? Because I did read a lot of different things about different comments about it, I just wanted to know, like, the professional view. Like, what do you think about this? Like, who is right in this case?
So it really depends on, it depends. If it's an advertising, it's a promotion, it's an offer. So you have to look at the original underlying documentation. Sometimes when they sell the price, like if it's like a barcode, it'll say when it's valid too. But sometimes a store, even though legally they can say, no, this is not valid because it expired, you know, here's the documentation that we have to prove that. Sometimes a store will make good on it because they don't want to lose a customer. So they'll override their own policy because they want to keep this person as a customer. They want to have goodwill. And sometimes they're like, listen, if we do it for you, we're going to have to do it for everybody else, and it's just going to be an incredible loss. And I will tell you something, if this was a year ago, I would say, you know, chances are maybe stores would let things kind of like that slide by. But now, with everybody struggling the way that they are, I don't know if, you know, stores are going to be as lenient, you know, in selling things for incredibly low prices, because everybody's doing really awful out there, you know, as far as the economy is concerned. So that's
Thank
just my
you.
opinion. You're welcome. Okay, so what is Lefkowitz versus Great Minneapolis Surplus Store about? Who wants to tell us about that case? Anyone?
There was a case about this guy who saw the advertising in the newspaper about a cow, I think was coat.
Yeah, fur coat.
Yeah, that it was like for $1 and it was worth like $100. And when he went to the store, they told him that there was like some house rules, I think it was.
Right.
So he left, and then he saw it the same like the next week again in the newspaper, but for a different price, but it's still saying like first come first serve. And he went there, and they say that like
Hold on.
he already knew the rules, and he
Correct.
didn't like sell the things.
You actually said it all correctly. I'm going to just excuse myself for 1 minute. If you heard, my 3-year-old wants milk, so I have to go get that. Hold on 1 second. Sometimes I feel like I'm being blackmailed by my 3-year-old because he's at that height now where he can open the refrigerator by himself. And so if I don't go get him what he wants, he'll just leave it open and he'll move on to destroy something else. So yes, it's wonderful working from home. But Barbara was correct. So he saw this advertising that says you could buy this coat for $1. He goes there and he tries to buy it. They're like, no, 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 there's a house rule that we're only selling this stuff to women. Then, so they refuse to sell it to him. Then he goes again to buy, like they had an advertising for like silk scarves or something else. Also, he's the first one. And they say, well, you know the house rule, so you can't buy it. Now, what happens is that this case is about, you know, advertising and advertising being clear and being definitive. And so their house rule was not actually written on the advertising anywhere. So they should have sold it to him, you know, first time around. He should have been able to purchase it because there was nothing that said in the advertising that you can't buy it unless you're a woman. The second one, once you're aware notice has been given, then you can kind of, you know, make a case for him not being able to buy that. So again, that case is simply just to know the difference between advertisings and actual offers. Good job. Good job, Barbara. Okay. When we talk about, this is a listening, not a writing. When we talk about policies between stores or companies, it's a little bit different than when we talk about contracts between individuals, because when two entities like stores or businesses or merchants are entering into deals with one another, sometimes their contracts don't have to be as detailed and definitive because they deal with each other on a regular basis. And so sometimes there are open terms that are left. So let's say you're buying seafood. You're a restaurant and you're buying seafood from a fisherman, okay? Or some kind of warehouse that has a lot of fish. You may say, I want like 100 pounds of whatever lobster, but the price may not be set yet because it's going to be based on market value. If there's a lot of lobster in the field, then you're going to be paying less for it. If there's not too many, then you're going to be paying higher for it. So some things are based on market value, the scarcity of a particular product in the field at that particular time. But that's not usually the case when it comes to, individuals buying things. I do want you to know, output contract, what an output contract is, okay? And an output contract is an agreement of a buyer to purchase a seller's entire output for a stated period. So again, an output contract is an agreement of a buyer to purchase a seller's entire output for a stated period. So when can we see that? Think of an example or something where you would buy somebody's entire lot.
Can you repeat that one more time, Professor? Sorry about that.
Sure. And I'm going to I'll put it for you in the chat if that makes it easier. Since
Thank you.
When we were in class live, I did not write on the board. I would just kind of just repeat things until people, wrote them down. But now that I have this little handy dandy chat thingy, and I can just copy and paste, makes it a little bit easier. So that's what an output contract is, an agreement of a buyer to purchase a seller's entire output for a stated period. Sometimes these types of contracts are beneficial because then a seller doesn't have to worry about, selling to multiple places. They can just produce and sell it. And a buyer is guaranteeing that, if there's a particular product that this seller is the only one that makes, they're kind of like cornering the market. So depending on the situation and the type of product being sold, it could be beneficial for both. Okay. Don't worry about a requirement contract. I just want you to know the output. Let me see here. Okay. Duration of offers. This is something I want you to know as well. Duration of an offer. How long or what are the ways that an offer can last, right? So an offer is given, and so you can accept it, right? If I make you an offer, you can accept it, but the offer that I'm giving you can also be terminated by a couple of different things. So how can it be terminated? Well, I can give you a time frame to accept it. So lapse of time is one. There's actually 7 different ways, so I'm going to just run through them and just write these down. These are pretty simple. They're just one words here and there. So it can be rejected by lapse of time. It can be rejected by revocation. It could be rejected by just flat out rejection. A counter offer. Number 5 is death or incompetency of either side. Number 6 is destruction of the subject matter. And number 7 is subsequent illegality. Number 7 is subsequent illegality. Okay, so those are the ways you can either accept an offer or reject it that way, any of those ways. Okay, here. Okay, next thing, is there any, I think these are all pretty self-explanatory, but if there's one that you want me to explain, I can. Anyone?
Can you repeat the first three? And I'm sorry.
Sure. Lapse of time, revocation, and rejection.
Thank you.
You're welcome. So is there anything that you would like as explained? I think they're pretty self-explanatory, but if there's something that you want explained after reading that you did not understand, I could explain it. All right, I'm going to move along. Okay. The next, somebody has to say something? No, okay. Sherrod versus Kidd. Who wants to tell us about that case? Sherrod versus Kidd. Anyone? Sherrod versus Kidd.
It was about the dog biting.
Okay.
I think the kid's dog bit the Sherrod, and they made a claim, and the kids offered the money. First, they offer like 31 something, then offer a little more. And I don't know.
That's okay. You know what? You're saving your class this evening, so that's good. I'll take over. Don't worry.
It was like basically I don't know if it was the judge or something. He basically assumed that the money wasn't like 32 something. It was like 25 something. Like they reduced the
You guys, both of them are actually correct. So there was an offer that was made to settle the case for $32,000, right? And that's what this case is about. There was an offer made to settle it for 32. There was no response. And so they went to arbitration. Arbitration is kind of like if you've heard the word mediation, arbitration, it's where it gets settled outside of court. And so up the arbitration level, the arbitrator awarded $25,000 to the person suing. So then they were like, oh, no, we'll take the 32. You can't do that. Lapse of time has happened. So clearly they were offered the 32. They didn't take it. And so they went to arbitration. It means they effectively rejected that 32 offer. It's no longer good. It's no longer on the table. So therefore, you can't go back and say that now I want to actually take that first offer that was higher. So that's what that case is about. Okay, good job. Good job, Barbara. Barbara, actually. That's good. That worked out nice.
They can't appeal this decision, right?
Well, I think they were appealed, and originally it was appealed, and then it was reversed. So it was reversed based on the stuff that I just told you. So I'm not going through like, the appellate division and then reversal and then going back to the trial court. The bottom line for this case, the point to know is once you reject an offer and you're going to move forward with the case, you can't then have the option of saying, oh no, I want that first number because it was higher. It's effectively a rejection of the offer that was made. Yes, lapse of time is the best way to do it. They didn't agree to it, but I would also even say it's not just lapse of time, it's also an effective rejection. So I would say it's for both. Okay, revocation, just to kind of say it, you can make an offer, but then you can just say, nope, I take it back as long as it's before somebody has accepted. Let me see here, from offer, okay. Is there any other ones that you don't understand or you want me to clarify before I move on to the next chapter? Okay, I'm going to move on to chapter 11, which is conduct that invalidates assent. What I'm about to say should sound somewhat familiar. It should actually ring some bells. If you entered into a contract and that contract was entered into based on duress or undue influence, that contract can what? Can be invalidated, right? Because the people that entered into the contract, they did not have a meeting of the minds. They both did not go into it willingly. Therefore, that innocent party, like I talked about before, it's a voidable contract. They can actually undo it. They can actually say that I was not of the mindset, I was being forced, and if you go to court, it can be actually undone. So that is a conduct that invalidates assent. So you can't make threats. You cannot make physical, trying to physically compel somebody to actually sign off on something. They're going to be able to undo it. The wonderful case that actually highlights the theory of undue influence, love this case, one of my favorites, it's Neugbauer versus Neugbauer. Who wants to tell us about Neugbauer versus Neugbauer?
So it's basically about there was a person, Pierre, Pearl, someone, Neubauer, and that person had a farm, and then I think husband died, and her son basically farmed that land and started renting it to Pearl. The Pearl offered $100 and something thousand to buy the farm, but the sons never accepted, and basically decided to go to speak to an attorney about purchasing the property, if I'm not mistaken.
It was a little bit different.
Yeah.
This like the husband and wife has a farm and 7 children, and when the husband died, two of the sons, like the partnership, they leased the farm from the mother. So it was for 10 years, and after like 10 years, the one son decided to buy the farm, but he was like consult his attorney, and the mother was trusted him, but she was old and uneducated, and she doesn't know the value of the farm, and the son wanted to like lie to her and wanted to buy like cheaper than it was worth it.
That's right. He bought the farm. He got her to go into a contract, and she had originally like offered to sell the farm to him back in 1984 for $117,000. And so then when he took her to the attorney to get it signed, in 2008 he got her to consent to actually paying for him to pay the $117,000. So in 2008 he was getting the farm for $117,000. Meanwhile, the farm was worth $697,000, so $700,000, and he bought it for $117,000. And when he took her to the attorney was his attorney, and the attorney didn't actually say that he was representing this person's interest only. The woman had only an 8th grade education. She was, hard of seeing, hard of hearing. She trusted her son, and basically her son screwed her. And the icing on the cake is he told her, don't tell any of my siblings about this. So once somebody tells you don't tell anybody about this, that's the red flag that that's something wrong. So then she goes home, she tells the other kids, and then they tell her mom, this is the farm is worth, like $700,000. So she calls up her son Lincoln and tells him, you have to invalidate this. It's karaoke time. Simon. Hey, my love. calls her son and she tells him, invalidate this. That's not what I wanted to do. And he refused. So she ended up having to take him to court. And the court found that there was undue influence there, that the mom did not understand what was going on. She did not have the requisite mind, the requisite capacity. And then they actually undid this contract because it was not a real contract.
Để cái đĩa ra cho cái bát lên trên.
So that's Neugbauer versus Neugbauer. You can also invalidate a contract based on fraud. So fraud as well. If somebody gives you a document to sign and okay, hold on 1 second. There's some you. Okay, and somebody tells you to sign something, and you think you're signing one document, but you're actually signing something else. That's fraud, and that can also be voided. Let me see here. What else do I want you to know? You know, misrepresentation and concealment. Those also are grounds to invalidate a contractual obligation on one part. Why? Because if you're concealing, you're hiding material information, that could be grounds for invalidating a contract. Both sides should know exactly what's going on to enter into a contract with one another. And so if you lie about something, if you hide something, if you fraudulently withhold information, that's also on you. Sometimes it's the burden is on the other side, but sometimes if you're actively withholding information, then that's a problem. And that's really the case of Reed versus King. And I'm going to tell you about Reed versus King unless somebody wants to tell me about that one. Reed versus
I can
King.
tell, but I'm afraid I'm going to make a mistake again.
No, that's okay. That's okay. It's fine.
It's basically about the person who purchased the house, and
Right.
about 10 years before there was a murder of a family, I guess.
That's right.
And that she sued the real estate agent because the real estate agent did not disclose this information in order, I think, not to decrease the market value of the house.
But it's not just that they did not disclose the information. What else was done?
Also, he told the neighbors to not to tell them.
That's right. They told the neighbors, don't tell any of the people that are coming to take a look at the house, don't tell them what happened in this house. So they went that extra step. Listen, when you're buying a house, you have to do due diligence. You should get the house inspected, pay for that. You should do your research, right? But if somebody's trying to actively withhold information, then that's actually grounds to sue or undo a contract. And that's what happened here. He purchased the house for a particular price. Meanwhile, because of the murder, it had reduced the market value of that. And so he should have been able to get it for lower. I think if the purchaser knew about the murder and was able to get it for a cheaper price, they would have still probably gotten it. But it's the fact that they overpaid the market value that was the problem. So that's concealment. In this particular case, it's hiding something. It's actively hiding something, and that's the problem. Let me just see here. What else? Okay. The next legal theory is it's called a mistake, mutual mistake, or mistake in the belief. Again, I'm going to go back to that whole thing of you have to know what you are getting into, right? Both sides have to have a meeting of the minds in order to be valid. If both sides are not on that same plane, then it's not going to be a valid contract. And the next thing, and it looks like I thought we were going to go into chapter 12 today, but it looks like we're finishing up at 11. That's great. The last thing that I want to talk about is assumption of risk when it comes to contracts, right? We talked about assumption of risk before when you were doing the skydiving thing, right? But assumption of risk could also happen in contractual obligations. If you are buying something at a garage sale, right? You could buy something and it could work, or you could buy something and it could not work, right? You are assuming the risk when you're making that purchase. You're giving the money, you're getting the product, there's no warranty. You're not going to be able to go back to that, seller and say, this clock didn't work, I want my money back. That's not how it works. Some things that you're buying are final sale. That's it. It's done. You're not going to be able to return it. So you're assuming the risk. You're getting it for a lower price, but you're also taking that chance that it may not actually fit. It may not work. It may not be good property, whatever it is. If you buy something at a garage sale, it could turn out to be that it's worth $1 million. It's an antique. Great. So you also bear the risk. Okay. Does anybody have any questions about any of the topics we covered tonight? Okay, I see one person who was alive and well and giving me a hedge that no. Okay.
Yeah, I just have one or two quick questions.
Sure, go ahead.
Can you repeat what the definition of preliminary negotiations is?
Sure. I don't think I actually gave you a definition on preliminary negotiation. I think I just said that it is something that not so much required, but it's part of the initial, it's an initial negotiation between the parties. So it shows that there's a willingness to enter into a contract. It's like just preliminary negotiation, initial negotiation to get to the point of contractual obligation.
Okay, and then what was revocation or revocation again?
Revocation,
Yeah.
that's just when you revoke an offer. So let's say I tell you, I'm going to make you an offer that you can buy my phone for $50, but you have to let me know by 10 o'clock tonight, right? I don't hear from you, but in 15 minutes, I notify you that I'm revoking my offer. I'm taking it back. That's something I can do. Even though I gave you a requisite period of time, since you did not accept, I can actually take it back.
Okay. All right. Thank you.
You're very welcome. Any other questions about the material that we covered tonight? Okay, I am going to tell you the results, the final results of the poll. The first question was, now that you've had both live and pre-recorded videos and finished your first exam, what do you prefer as your learning method? 86% of you prefer the pre-recorded video. Question number 2, how do you rate your first exam? 71% said it was fair, and it's actually a tie of 18% each between easy and hard. So since the majority felt it was fair, and like I said before, for those who came late, most of you did very well. This class actually did very well in the exam, so I was very happy to see that. The next exam is in a couple of weeks, and according to your syllabus, it's going to be October 26th. So it's at the end of this month. It's also going to be multiple choice and true and false. I'm not sure how many yet. I have not made it. I am modifying all the exams based on this new thingy. Why is there no exam next week? Let's see here. No class. What's today? 10-5. Oh yeah, next week is Columbus Day. That's correct. So I'm not going to see you guys until October 14th. So not this week, next week. Whatever the 14th is, I will see you then. Okay? Does anybody have any questions? Actually, the 14th is next week, right? Hold on.
Yes, because Columbus is 12.
Let me see here. Next week, no class. Columbus Day. I have to check the CSI thing because I still have it on
19, you mean? October 19, because the next week is October 12th.
Yeah, October. Oh yeah, that's right. So next class is the 14th. So it's probably where it's like a day in the middle of the week where they make it a Monday schedule. So that's why I have on the syllabus October 14th is the next time I see you. So it's in 9 days.
This is so weird.
Yeah, that's CSI does that. Wednesday will, yeah. So I will see you on the 14th, which is a Wednesday. Have a great evening. Again, if there's any questions or concerns, you can just email me. All right. Have a good night, everyone.
Thank you. Have a good night.
Bye-bye.
Night.
Good night.